Did you know that your property rights might not be as absolute as you think? In Louisiana, servitudes place legal limitations on ownership, allowing others certain rights to use or access your property. Understanding servitudes is crucial for notaries handling property transactions. In this video, we break down Chapter 9 on servitudes from the 2025 Fundamentals of Louisiana Notarial Law and Practice book. So what is a servitude? A servitude is a legal right allowing someone else to use or benefit from a part of your property. Think of it as an invisible restriction that runs with the land, affecting how an owner can use it. Louisiana law divides servitudes into two main types, personal and predial. First, let's cover personal servitudes. A personal servitude benefits an individual rather than a piece of land. This type of servitude is attached to a specific person and does not transfer with the property when sold. Personal servitudes typically end when the individual dies or after a set period. There are three types of personal servitudes. First, we have Usufruct. This gives someone the right to use and enjoy another person's property, including collecting rent or profits from it, without actually owning it. It's pretty common in estate planning. Next, there's the right of use. This is a more limited right, allowing someone to use a property for a specific purpose, like granting a business access to a private road. Lastly, we have habitation. This grants someone the right to live in a home owned by someone else, but without the right to lease or sell it. Let's break these down one by one. Civil Code Article 535 explains that a usufruct is a real right of limited duration on the property of another. It allows someone, called the usufructuary, to use and enjoy a property as if they were the owner, but without actually owning it. That means they can live in the home, rent it out, or even harvest resources from the land depending on the terms. Let's consider an example. If a parent passes away and leaves property to their children but grants their surviving spouse usufruct, the spouse can live in the home or rent it out until their death. After that, the children gain full ownership. However, usufruct has limits. The usufructuary can't sell the property itself. That right belongs to the actual owner, called the naked owner. And if the usufruct covers something consumable, like money in a bank account, the usufructuary must return an equivalent value when the usufruct ends. A habitation servitude is a more restricted right than usufruct. It allows someone to live in a house owned by another person, but that's about it. So what does habitation allow? It allows the right to live in the house for free, unless otherwise agreed, and the right to bring in family members to live with them. But what about what habitation does not allow? That is, the right to rent or lease the home to someone else, and the right to make significant alterations or sell the property. For example, a homeowner may grant their elderly friend habitation rights in their guest house. The friend can live there comfortably but can't turn it into a rental or let strangers move in. Unlike usufruct, habitation rights are strictly personal and can't be transferred to someone else. When the person with habitation rights passes away or the agreed time expires, the servitude ends. A right of use servitude is similar to usufruct but more limited. It allows someone to use a property for a specific purpose without giving them full control over it. Let's consider this example. A business owner is given the right of use to a private road on someone else's land to access their storefront. They don't own the road, but they can legally use it. Here's another example. A farmer is granted the right to fish in a pond on a neighbor's land. They don't own the pond, but they can use it for that specific purpose. The key difference between right of use and habitation or usufruct is that right of use can be transferred unless stated otherwise. That means the holder of a right of use servitude could sell or lease their right to someone else, depending on the terms of the agreement. Now that we've covered personal servitudes, let's talk about predial servitudes. A predial servitude is a right that benefits one property, called the dominant estate, while burdening another, known as the servient estate. Unlike personal servitudes, predial servitudes transfer with the land when it is sold, affecting future owners. Examples of predial servitudes include a landlocked property having a right of passage over a neighbor's land, drainage servitudes that allow water to flow through another's property, and utility easements for power lines, sewer access, or pipelines. Predial servitudes can be classified into three types. Natural servitudes, which arise from the natural situation of the land, like drainage rights. Legal servitudes, which are imposed by law for public necessity, such as building restrictions or access rights. And finally, conventional servitudes, which are created by agreement between property owners. Servitudes can be created in different ways. By law, such as legal access rights for landlocked property, by agreement, through written contracts between owners, and by prescription, which is established over time through continuous use. They can also be extinguished when the need for the servitude no longer exists. The dominant and servient estates become one property, or the servitude isn't used for a certain period if subject to prescription. As a notary, recognizing servitudes is essential when preparing property documents. Missing an existing servitude could lead to legal disputes or problems in real estate transactions. Servitudes shape property rights and are a key part of Louisiana's civil law system. Whether it's a right-of-way or a usufruct, understanding these legal principles is crucial for notaries. Want to learn more? Be sure to like, subscribe, and hit that notification bell so you don't miss an update. Thanks for watching.